it at Holland and Hart. I hope that wherever you are, it's 72 and sunny like it is in Salt Lake today. Today we're going to be talking a bit about the COVID-19 pandemic and telehealth, the changes that have been implemented by various agencies since the beginning of this public health emergency, and what we've seen, what we may be able to expect to see on how that's going to go. We're going to talk about, first of all, we're going to talk about the, let me just advance our slides a bit here. First of all, we're going to talk about the COVID-19 Telehealth Program. This is a new federal program designed to provide funding to increase telehealth services. We're going to talk about some of the federal waivers that are out there and some of the state waivers as well, and other adjustments that have been made to expand telehealth during this pandemic. We're going to talk, just kind of reminders about things that you need to think about as we're working through these changes at the federal and state levels, just so that we're not rushing ahead in light of a change that one agency has made and not taking into account some of the other rules and regulations and contract issues that need to be kept in mind before we really set about expanding telehealth services. And finally, we're going to be looking ahead to what's going to happen after this public health emergency is over. Spoiler alert, it's a bit unclear. We do have some not really guidance, but we do have suggestions from CMS that they'd like to make some of these changes permanent. But that's going to be down the road, but we'll talk about those issues.
Hey, Corey.
Yes.
Can you get a little bit closer to your phone? The sound is not so great at the moment.
Is it not picking up? Is that better?
Oh, much better. Yeah, that's great. Thank you.
Okay, there we go. I apologize, everybody. I had put on a headset for this and left it on speakerphone, so I apologize if you couldn't hear. Hopefully you heard well enough, and we can just move along. It was really just sort of an overview of what we'll be talking about anyway. Okay, so let's talk first of all about the COVID-19 Telehealth Program. This is part of the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. And as part of that, Congress set aside a decent amount of money, $200 million, to be distributed, and that is for emergency funding for healthcare providers to increase telehealth services during the COVID-19 pandemic. At this point, that has been limited to public and nonprofit healthcare providers. We'll talk about that a little more later, but there is that limit on the program. And the way the process works is that interested providers can apply for an award of funds to increase their telehealth capacity, and the FCC is the evaluator of those applications, and they have set a ceiling, an award ceiling of $1 million per applicant. Good news is you can reapply if you get that $1 million and need more. You can apply for a second round. Okay, so let's talk about what it is. The program is designed so that healthcare providers that participate in the program can have their telecommunications services, information services, and devices necessary to provide critical connected care services fully funded. The funds can be used to cover eligible equipment or services purchased on or after March 13 of 2020, and that includes services that have a monthly recurring charge, so broadband internet, for instance, connectivity, remote patient monitoring devices, those sorts of things. Those will be paid for, those monthly recurring charges, through September 30th of 2020 for successful applicants. So who's eligible for this? And this is where you sort of get a little bit of confusion as we mix and match various federal acts. And the CARES Act refers us back to the 1996 Telecommunications Act, and in particular, Section 254H7B, which is federal law at its clearest right there, for a list of the entities that are eligible to apply for these funds under the telehealth program. Post-secondary educational institutions offering healthcare instruction, teaching hospitals and medical schools, community health centers or health centers providing healthcare to migrants, local healthcare departments or agencies, community mental health centers, not-for-profit hospitals, rural health clinics, skilled nursing facilities, or if you have a consortium or consortia of healthcare providers that are part of that group of entities that I just went through, that group then would be eligible to apply for these funds. Now, what you'll notice if you're going through that process is that this section of the Telecommunications Act is actually limited to rural health clinics only. But that is where the CARES Act differs from the Telecommunications Act. And so this funding, although it refers to a section of the Telecommunications Act that applies only to rural health clinics, actually applies to rural and non-rural health clinics. But again, they still have to be nonprofit or public health facilities. People are trying to expand that. The most recent plea that I saw for that was the American Dental Association trying to expand this to include dentistry. There have been pushes to include private providers as well. So far, that it hasn't changed, but be aware that there are efforts out there to expand the scope of the telehealth program. Okay, what's covered? All right, so you apply, you get funding. What can you use that funding for? First of all, telecommunications services and broadband connectivity services, not surprisingly. So if you need voice services for healthcare providers or for their patients, that's appropriate to use funding for. Information services like internet connectivity for healthcare providers, again, or for their patients. So remote patient monitoring platforms and services, patient-reported outcome platforms, store and forward services such as asynchronous transfer of patient images and data for interpretation by a physician, platform services. You can read the rest of that. Okay. Connected devices and equipment are also appropriate under this program. So if you need tablets, if you need smartphones or other connected devices to receive connected care services at home, like broadband, enabled blood pressure monitors, pulse oximetry monitors for patients or healthcare provider use, those sorts of things are available and would be covered by the telehealth program. The program does not cover, though, a lot of the support that goes along with these services or devices. And so if you need to hire new personnel to run an expanded telehealth service, that's not going to be covered. If you need additional IT support, that's not going to be covered. If you need additional administration, it's not going to be covered. Your training costs to get up to speed on the new equipment or new services, not going to be covered. Those go beyond the scope of the telehealth program. So what is the FCC looking at? The FCC has set out 6 criteria that it will look at to evaluate applications under the telehealth program. The first is the conditions to be treated using the program funding. Now, it's a little unclear how that will be weighed, because obviously if you're using telehealth to treat coronavirus patients, that's a plus. But if you're also using it to free up space at facilities so that additional coronavirus patients can be treated, that seems to fit the same bill. But it does, that criterion there does seem to be related to how does that play into the current public health emergency, and will we be able to increase services specifically to address this current public health emergency? Second, the goals and objectives for use of the funding. And again, as the tighter that use is tied to the current public health emergency, the more that criterion will favor an applicant. The timeline for deployment of the proposed services or devices, and not surprisingly, here the agency is going to be the FCC is going to be looking at, is this something that you can get up and running during this current public health emergency? If you've got a great system that can be put in place in 2021, that's going to be less favorable to the FCC than somebody who can get a decent system in place over the next couple of weeks and be able to assist in the current public health emergency. Next, the factors or metrics the applicant will use to measure the impact. It's important to be able to track what benefits you're going to be able to get from the additional telehealth services, and so that's something that sometimes it can be very clear that you'll be able to expand into certain facilities that didn't have telehealth services before, certain classes of patients that you weren't able to provide telehealth services to before, and so it's important to point that out. The geographic area and population is the next factor that's being considered, and not surprisingly here, the concern is this going to provide services to people who are currently not being served? And so we look at low-income patient population, where there's healthcare provider shortages, hospital closures that have impacted the access to healthcare in these areas, and so those sorts of factors that come into play in the geographic area that you're looking to serve with these funds will be an important criterion as well. And then finally, the targeting of the funding to impact positively high-risk and vulnerable patients is a real key consideration of this program. It's also a key consideration of additional congressional action that is sort of in the works now. That really is the focus of what they're trying to do, is to impact those people. All right. So how do you go about applying for funding under the program? It's not surprisingly a multi-step process. The first is you have to seek an eligibility determination from the Universal Service Administrative Company for each site that's going to be included in the application. Now, at the bottom of this page, you'll see a link to the FCC site regarding the telehealth program. And on that site, they link to the USAC site where you can fill out the form to get that eligibility determination. And just sort of a reminder, the form that USAC uses requires you to fill out a section regarding the fact that you're a rural healthcare entity. And again, it's because that form is designed to fit into the Telecommunications Act that we discussed earlier. And the CARES Act, where this telehealth program is found, is broader than that. And so that section of the form is really irrelevant to what you're doing. So don't panic if you get there and find that the reference to the rural health facility, and it doesn't apply, because it doesn't apply under this program. Second step, after you've submitted that eligibility determination, you don't need to wait until you get confirmation from USAC. All you need to do is apply. Once you've applied for that, then you can move on and get an FCC registration number. And then you can register with the federal system for award management. Again, links to all three of those sites that are required for your eligibility determination, the FCC registration number, and the system for award management, are on the FCC COVID-19 Telehealth Program site. And so I've linked to that site there. And then once you've got those three preliminary steps out of the way, then you submit the application through the FCC, and that's an online process through that link that's on the page there. Okay, so that is the COVID-19 Telehealth Program. They've already started issuing awards for that, and so again, there's money there. They've Congress has allocated $200 million for that, but it is a limited supply. And so if you're interested in that program, I would encourage you to move quickly and before those funds are gone. And once they are gone, hopefully that'll be replenished by Congress. But for now, that's the pool of funds that are available. All right, let's move on then from the telehealth program and talk a bit about what else the federal government and state governments have been doing to increase telehealth services during this public health emergency. Okay. We're going to talk about a few things in this section. First, we're going to talk about what CMS has done. CMS has put out a series of telehealth waivers and made some changes to expand telehealth services. There has been enforcement discretion allowed from OCR under HIPAA, and we'll talk about that because it's the scope of that is a little unclear. And at least for attorneys, that's raised some red flags. We'll talk about flexibility to address cost-sharing obligations with respect to federal health care programs, and with respect to that, the Health and Human Services Office of Inspector General has allowed providers to waive cost-sharing obligations under certain circumstances. And then just a brief reminder that, again, whatever these federal changes are, don't forget that we need to consider what's happening at the state levels as well, and also what your contracts require. A good example of that is, what does your insurance require? We've got these broadened telehealth CMS guidelines now that say, for instance, that they get rid of the geographic requirement allowing telehealth services to be provided across state lines. Well, what does your state say about that? Does your state allow that to happen with current licensure? What about the state where those services are being provided? What about your insurance contract? Is that going to be covered under your malpractice policy if you're providing services across state lines? Just things to consider, and we'll talk about that a little more. Okay, let's talk just briefly about the timeline here for CMS. At the end of January, Secretary of the Department of Health and Human Services declared a public emergency, saying that that emergency exists and has existed since January 27. And what that did is that the public health emergency under the HHS rules lasts for the shorter of 90 days, or when the Secretary declares that the public health emergency no longer exists. We're still within that initial 90-day period. It can be extended for consecutive subsequent 90-day periods as needed. But that's sort of the time period that we're working in under the current public health emergency. And that public health emergency is what allows CMS and some of these other federal agencies to expand their rules and adjust them to account for this public health emergency. So on March 6th, then, we started to see funding come in, and there have been a couple federal congressional bills have been put into law allowing for funding. That was the first one on March 6th, though, providing emergency funding for federal agencies that included an expansion of Medicare coverage for telehealth services, authorizing Health and Human Services to waive certain Medicare telehealth payment requirements during the public health emergency. Okay, so that's how the statute sort of fits with the declaration of a public health emergency, which allows these agencies to expand what they've been doing. All right, so traditional CMS standards, as far as telehealth goes, prohibited reimbursement for telehealth services provided to a Medicare beneficiary at home except for virtual check-ins. Limited telehealth services were covered, including remote monitoring services, physician interpretation of diagnostic tests, other non-face-to-face care management. And with this public health emergency, that has now been expanded so that Medicare beneficiaries can receive specific set of services through telehealth, including evaluation and management visits, sort of common office visits, mental health counseling, preventive health screenings, and it will ensure that the people who are really at higher risk, Medicare beneficiaries, are generally at higher risk for COVID-19 given their age and frequent underlying health conditions. They're able to go visit with their doctors from home without having to go to a doctor's office or hospital. And that, of course, then lowers the risk to them and to others. And that's the rationale for expanding these types of services. Okay, so let's talk about some of these changes that are effective for services starting March 6th. All right, temporary changes, and I need to stress that right now. The changes that CMS has made are temporary. They last during the pendency of this public health emergency, but so far CMS has not gone beyond that time period. And so while this public health emergency is in place, there are rules allowing an expansion of telehealth services, but that is not permanent. Let's talk about some of those temporary changes. First, patient location requirements. The Medicare originating site requirements are waived. So this allows telehealth services to be provided regardless of where the beneficiaries are located. So they can be located at home, and you can have a telehealth visit. You can have telehealth services provided to somebody in their home and outside designated rural areas as well. Practicing across state lines, and this is the reason there is a big red flag on the screen right here. CMS waiver allows practitioners to furnish telehealth services across state lines now, okay? But that is still subject to state law, state licensure law in particular. And so before you just view this as a green light to go ahead, this is something where checking the state law and any changes in state law is critical. Now, fortunately, most states have made licensure changes to address this very issue. The Federation of State Medical Boards has a really helpful list, and I've linked to that showing the changes that have been made. Now, fair warning here. I think the list is a couple weeks old, and during this pandemic, changes are coming fairly fast and furious, and so that may not be up to date, but it will at least give you a starting point of somewhere to look to see what your states are doing with respect to licensure for telehealth services. And I think the last time I looked at this a couple of weeks ago, I think there were 49 states have made adjustments to their licensure rules to allow for an expansion of telehealth services. So there are a lot of changes, and if you're just relying on what you knew 2 months ago or 3 months ago, it's very likely different now. Okay, other changes, types of telehealth. Now, telephones with audio and video capacity can be used to provide telehealth services, and so that then gets us beyond two-way, real-time interactive communication technology, and again, designed to expand telehealth services. Relationships. Physicians can now see new and established patients for telehealth and remote patient monitoring and virtual check-in using communications technology. And so you have an expansion there as well. Services. CMS has significantly expanded the list of services that can be provided by telehealth. It includes emergency department visits, initial nursing facility and discharge visits, home visits, therapy services, and I've linked here to the current CMS site regarding the list of covered telehealth services, so you can go there and review those expanded telehealth services. Okay, more changes. Newly eligible providers. Under telehealth, first, federally qualified health centers, rural health clinics can now provide telehealth services to patients wherever they're located, including in their homes. Again, important to point out, this is temporary. This is not a permanent change to eligible providers for telehealth services. This is a temporary change, but a really helpful one. Supervision of physicians. Physicians can supervise services through audio and video communication instead of just in person. Now, again, this is helpful, but it's also something you're going to want to look and make sure that this is consistent with your state rules. Modality for telehealth services, a telecommunications system would mean multimedia communications equipment that includes at minimum audio and video equipment, preventing two-way real-time interactive communication between the patient and distant site physician or practitioner. That is actually a rehash of what we talked about just right above. Okay. All right, let's move on and talk about HIPAA. And this is one where HIPAA came out, OCR came out with notification of enforcement discretion that would authorize providers to use, pretty popular communication apps to communicate with patients, and the goal being that if you were using those to, in good faith, provide telehealth services, you wouldn't be at risk for penalties that ordinarily OCR would impose for providing services using those apps. And so that was the goal of that notification of enforcement discretion. This is what it did. It says that covered providers can use popular non-public facing applications to deliver care. And so what happened was HHS actually listed examples of the types of applications that you could use on its telehealth website, saying, okay, here are examples of video chat applications, and this is the list from HHS's website: Apple FaceTime, Facebook Messenger, video chat, Google Hangouts video, Zoom, Skype. Had text-based applications like Signal, Jabber, Facebook Messenger, Google Hangouts, WhatsApp, and iMessage. Those are all directly from the HHS telehealth site, saying you can use these to deliver care. Very clear, though, you cannot use public-facing platforms like Facebook Live, Twitch, or TikTok that multiple people can view to provide telehealth services. They also noted, though, that if providers wanted to use additional protections, then they should provide services through technology vendors that are HIPAA compliant and will enter into HIPAA business associate agreements. And again, HHS lists examples: Skype for Business, Microsoft Teams, UpDocs, VC, Zoom for Healthcare, DoxyMe, Google G Suite, so on, so on, so on. Okay, so it lists those on the website. This and that's all well and good as far as it goes, but what's concerning is sort of what's happened since then. So we get that, and HHS then puts a disclaimer on it. And oh, sorry. So we get that, and before I talk about the disclaimer, follow-up Q&As with HHS has made clear that, look, even if you're using this, you still need to, and this is not surprising, you still need to take reasonable precautions to try to safeguard patient privacy. Close your office door. Don't use the speakerphone. Don't shout. Try your best to keep it your conversations private. Okay. So this is where this gets a little muddy, though. We have the HHS listing those apps on its website. At the same time, HHS disclaims any endorsement of those particular apps. And what's happened since HHS listed those is people have raised security concerns about some of those applications. I think the most famous one is Zoom. You've probably seen stories or heard stories about Zoom bombing, or maybe you've actually seen them. These happen. Zoom is not encrypted from end to end. And so there are some security risks that people have pointed out. Zoom has pushed back on those. and said that those security risks are overstated, and that its product is secure. But in light of what's going on with that app, and perhaps with some of the others that are listed on there, is it still reasonable for a provider to expect that patients will be afforded privacy if those apps are used? And for the moment, that's a bit of an open question. We know, for instance, the New York Attorney General is looking into that issue to determine whether Zoom provides adequate privacy for patients. But again, we just don't know. What we do know is the app's currently listed as an appropriate one, as an example, I should say, not appropriate, but as an example of an app that can be used on the HHS website. What does that mean, though, in light of these other security concerns? We don't know. But I raise that because if you are using these applications to provide telehealth services, please be aware that there is a risk to doing so, notwithstanding OCR's notice of enforcement discretion. Okay, let's talk about cost sharing next. And this issue came up just over a month ago. The HHS Office of Inspector General issued a policy statement, and this was based on the earlier HHS declaration that a public health emergency exists and has existed since January 27. And what OIG said is that physicians and other practitioners, will not be subject to administrative sanctions for reducing or waiving any cost-sharing obligations federal health care program beneficiaries may owe for telehealth services furnished consistent with the then applicable coverage and payment rules subject to the conditions specified herein. Okay, so what does it mean? If you have, for instance, if a qualified beneficiary has a copay obligation, the provider can waive that copay obligation. And this is something that was generally barred as a potential violation of federal kickback statute. So that's the issue that OIG was trying to resolve. Okay, and so I said, here are the conditions where this applies, right? Because that guidance only applies under the conditions specified in the OIG policy statement. Okay, and there are two conditions you have to meet. One, that the practitioner is reducing or waiving cost-sharing obligations that a beneficiary may owe for telehealth services furnished consistent with the applicable coverage and payment rules. Okay, you've got the waiver part there. And two, they're being furnished during the time period subject to the COVID-19 declaration. Again, that's that public health emergency. We're still in that 90-day period, and so currently we're within that time period. And so, if those services were provided since January 27 through the present, they fit that category for two. And then the question is, simply whether the physician or practitioner reduced or waived the cost-sharing obligation. If it did, then it fits within that policy statement. So what does it mean? First of all, waivers of cost-sharing can be violations of the federal anti-kickback statute. And this policy statement does away with that, saying that the provision of free telehealth services alone is not going to be viewed as an inducement or is likely to influence future referrals. Now, I would highlight the alone part of that. If there are other indicia that the services are an inducement or is likely to influence future referrals, then it still could be part of a violation of the anti-kickback statute. And so just flag that guidance does provide a bit of a safe harbor, but if there are other indicia that it's used as a violation of the anti-kickback statute, that still can come into play. It does not require Moving on then, policy statement does not require providers to reduce or waive any cost-sharing obligation. It simply notes that if providers choose to do so under those circumstances, it will not be viewed as a potential violation of the anti-kickback statute. Okay, and then I think sort of the obvious point. This doesn't waive any other requirements that you may have, any other responsibilities. For instance, to bill only for services performed. This is not a waiver of that requirement, which I think surprises nobody. Okay. Another point that has changed with this is online prescribing requirements, and this is one where under the HATE Act, there had to be an in-person meeting in order to prescribe various scheduled and non-scheduled substances. And so HHS early on in March issued a statement regarding online prescribing requirements saying public health emergency exception to the in-person medical examination requirement would apply. And that applies to non-scheduled controlled substances and Schedules 2 through 5 controlled substances. Those can be prescribed online if these three conditions are met. One, the prescription is issued for a legitimate medical purpose by a practitioner acting in the usual course of his or her professional practice. Two, the telemedicine communication occurs using an audio-visual, real-time, two-way interactive communication system. And three, the practitioner is acting in accordance with applicable federal and state law. Again, you should not view this as carte blanche to violate the Drug Enforcement Act. So that's a change where, again, you've got to be careful about what that means in your state, and not just take the federal change to the HATE Act at face value, but without checking to what your state requires. And so now that we've kind of gone through some of these changes that the federal government has made, here are some reminders before you just launch into these providing telehealth services that have been expanded. Okay, check your state, and I've said this several times, I hate to keep beating this, but it's important. You've got to check and see what your state is doing so that you're not violating state rules and regulations or state laws as you expand telehealth services. One example of this is, again, with the removal of the geographic restriction under Medicare. That doesn't change state rules and regulations for licensure. And so if you've got services that are crossing state lines, you need to make sure that you're okay under the distant and originating site state licensure laws. And so, again, check your state licensure law, check any states where you would be potentially providing services. Consent. Be sure you know what you need for informed consent. And so, again, if you're crossing state lines, informed consent can differ from jurisdiction to jurisdiction, and you need to know what each jurisdiction requires to provide informed consent in those jurisdictions. Standard of care, again, as a general rule, there's not going to be a difference in the standard of care for telehealth versus in-person care. How is that going to be impacted by the current public health emergency? Maybe not at all. Maybe it is some, just given volume for certain emergencies that are being addressed in certain areas, certain jurisdictions, certain time frames. We just don't know yet what that is. And I would also note that as you start expanding telehealth services across multiple jurisdictions, the standard of care can differ from state to state. And so it's important to keep in mind what the standard of care is. And insurance, finally, this is the last example of something you need to look at. Before you start providing telehealth services across state lines, you need to make sure that your malpractice insurance covers that. Otherwise, you're putting your facility at risk. Okay. So those are some of the changes that have been going on. What's next? And this is where, bipartisan congressional support for additional expansion of telehealth services. I've seen various Congress people advocating for pushing for more broadband internet access and taking other steps to expand telehealth services during this public health emergency. It's especially targeted at high-risk individuals, seniors, and people with underlying health conditions, people in areas where there have been hospital closures, people in areas where in rural areas that could easily be overwhelmed due to the public health emergency. And so we're sort of waiting to see what happens with that, but we do know that Congress is thinking about that both parties have been pretty vocal in advocating additional expansion of telehealth services. Okay. CMS issued something that I think is really hopefully going to be helpful. Last week they released a toolkit to help states remove barriers to telehealth services. And what CMS is doing is it's provided this toolkit to the states, and it's hoping that they'll go through and fill out the lists for telehealth services in Medicaid and CHIP programs to expand telehealth services and provide CMS with a breakdown of what issues each states are looking at and what the barriers are in place for telehealth services. The toolkit, like it says, it aggregates information, highlights questions that states may ask themselves when establishing new telehealth policy, including telehealth policy for pediatrics. I included here kind of a snapshot of a part of this survey that goes through different questions for states to consider what they are doing with their telehealth services. And so you'll have a question, can a new patient-provider relationship be established via telehealth? And then you'll input your state policy and enter the next steps to remove barriers for that. It's a bit early on. This was only done last week. I think maybe one state, maybe Ohio, has filled this out, at least in part, and circulated that back to CMS, but it's a bit early on to see what's going to happen. But the point of the program is to help states identify which aspects would impede the rapid expansion of telehealth services in their jurisdiction. CMS notes they have really broad flexibility to cover telehealth services, and they may want to reevaluate the scope of their practice laws. I think providing states with a hint that look, we really need you to expand the ability to get services to Medicaid and CHIP programs. So the toolkit then suggests how states can address issues regarding privacy, provider licensing, and pediatric telehealth services as well. So it's a little unclear what's going to happen going forward other than this. One, I think we can count on continued expansion in some way, shape, or form of telehealth services, whether that is providing funding to bolster services under existing laws, rules, regulations, or the removal of barriers to expanding telehealth services by amending laws, regulations, and rules that are currently barring the provision of telehealth services. Some resources that might be helpful for you. We have our firm has a coronavirus website, and you can go in there and search by industry and healthcare industry. There's a section that sort of compiles the changes that we have seen. Those really are just sort of sites. Generally, I think there are a few articles in there that we've prepared, but by and large, those are simply the raw materials from federal agencies that we've been provided. Keep an eye on guidance from the Department of Health and Human Services. They have a special dedicated telehealth website that you can view, and HHS has also linked to the Center for Connected Health Policy site, which also has a COVID-19 telehealth coverage policy page, which is pretty up to date and pretty helpful too. So those are some resources that you can use. And to get guidance. If you do have any specific questions, feel free to reach out to me or any other attorney, and we'll get you the information that you need. And other than that, thank you very much for your attention, and good luck. Again, if you have any questions, please let me know. I'm happy to respond. Thanks.